Okay, it is 1 o'clock. Welcome, everybody. Thank you for joining us this afternoon to talk about the recent decision by the Supreme Court, Dobbs versus Jackson versus Women's Health Medical Center. I'm Sonia Suter, the Kahn Family Research Professor at the George Washington Law School, and I'm joined by two other colleagues to talk about this. I will let Sara and Alan introduce themselves.
Hi, I'm Sara Rosenbaum from the Milken Institute School of Public Health.
I'm Alan Morrison. I'm the Lerner Family Associate Dean for Public Interest Law, and I teach constitutional law at the law school.
Great. And with us today also is Zoe Beckerman, a teaching associate professor and vice chair of academics in the Milken Institute School of Public Health's Department of Health Policy. Zoe is going to be organizing the questions that come from the audience today and then sharing them with all of us when we get to the Q&A portion of our session. So I want to start off by emphasizing that the webinar today is intended to focus on the healthcare and legal implications of the Dobbs decision moving forward. We explicitly decided not to dive deeply into a discussion of the legal and constitutional underpinnings of the decision because there's so much to talk about in moving forward after this decision. So our plan today is to cover a number of areas related to the healthcare and legal implications of the decision in the first 40 minutes or so of the webinar, and then we're going to leave another 20 minutes or so for questions. Please feel free to put your questions in the Q&A chat at any point during the session. As soon as you have a question, just put it right in there. And finally, I just want to emphasize that this is going to be more conversational than sort of formal presentations. So I'm going to start by setting the stage, very briefly highlighting the majority, concurring, and dissenting opinions of the case. So the case concerned a 15-week ban, Mississippi ban on abortions, which under Roe and Casey would be unconstitutional because they prohibited abortion bans before viability, which is about 23 to 24 weeks. With the change in the composition of the court, with Justice Barrett replacing Ginsburg, Mississippi then asked the court not just to consider whether the statute was constitutional, but whether to overrule Roe and Casey outright. And of course, as everybody here knows, the court in a 6-3 decision upheld the Mississippi law, and in the majority decision, 5 justices agreed to overturn Roe and Casey, which was essentially changing precedent of nearly 50 years. The majority's analysis was first to state that both cases were, quote, egregiously wrong. But the court essentially had 2 parts to its argument in saying that there's no fundamental right to abortion under the 14th Amendment of the Constitution. The court said first that there's no mention of the word abortion, or for that matter, privacy, in the Constitution, and that abortion rights aren't deeply rooted in our nation's history and tradition. The court looked back in history and concluded that there was no official right to abortion at the time of the 14th Amendment's ratification, and therefore not part of our history and tradition. The court also spent considerable time addressing the question of stare decisis, whether precedent should stand, which is generally what the court does. And it argued basically that the court's reasoning was poor in Roe and Casey, that the tests for constitutional analysis under Casey were unworkable, and that there were no concrete reliance interests on the right to abortion. It was just too hard to figure out exactly what would happen if we banned abortion. And while the majority repeatedly stated that its holding was only dealing with abortion rights and had no bearing on other rights determined under substantive due process, Justice Thomas wrote separately to say, well, actually, substantive due process is really problematic, and we should reconsider any rights that we've granted under substantive due process. Justice Kavanaugh wrote separately to argue basically that the court was being scrupulously neutral, that the Constitution says nothing one way or another about abortions, and that we should leave the matter to the legislatures. Also, that none of the constitutional rights that Thomas talked about are under threat. And finally, that there's a very clear constitutional right to travel. The Chief Justice wrote basically to agree with the holding of the statute, to say that that statute was okay, but he argued for judicial restraint and said that the court should not have reached the question of whether to overturn Roe and Casey. And then finally, the dissent in a joint opinion by Justices Breyer, Kagan, and Sotomayor, writing all together, not separate dissents, critiqued the majority for failing to, for discarding essentially the balance that had been achieved in Roe and Casey between the various values and goals. It also spent considerable time laying out the concrete harms that would result with this decision. So harms to women's health, financial harms when people can't access abortions, threats to equality, and threats to other rights. So although the majority said it wasn't dealing with other rights, the dissent pointed out that the logic would apply to other rights under substantive due process. And it also talked about how this decision was really undermining the integrity of the court. So what we have now, in just a little over a month since the decision, a very confusing state of the law. We have 10 states with bans, one that's expected to have another ban, 4 bans that are blocked, another 4 states with 6-week bans, another 2 states with 15-week bans, and lots of litigation about the bans in many states, lots of movement and uncertainty at this point. That's sort of the background about the law. So I'm going to turn now to Sara to talk about sort of a high-level description of the impact and how the post-Dobbs world is different than the pre-Roe world.
Thank you, Sonia. I have spent the past 6 weeks basically trying to wrap my head around what this decision means for those of us who think about health law and policy. And I've decided that given how much pregnancy care has evolved, how much the healthcare system has evolved, how much we know now about managing safe pregnancies, about making sure pregnancy is safe, that this decision essentially knocks pregnancy care and the cluster of services leading up to care during a pregnancy right off its medical foundations. I mean, it's as if, it's not as if, the court made clear that it did not consider a need to balance any of these issues at all. They essentially left it to states to decide what the standard of care would be, and we've never really faced anything quite like this in all of health policy. For 2 centuries, we've been a country that, for better or worse, has operated on something called the professional standard of care. That concept has changed over time. But what you look for in the modern era is sort of the judgment of professionals as backed up by evidence. And so to just say that there's a whole part of pregnancy care, and it is, very much, as we're seeing, pregnancy care that is off the table now potentially is astounding, and it explains a lot of what's going on here. So, how has the world changed? The world has changed because we have a completely different world in terms of being able to plan a pregnancy, in terms of being able to prevent a pregnancy from occurring. And that, of course, helps explain why the abortion rate, it's still high in the US, has dropped dramatically. We have a whole different world in terms of very, very early termination of pregnancies. About half of all pregnancies are getting terminated really within a few weeks of the onset of the pregnancy. And the notion that somehow everybody is electing to have later stage pregnancy is a complete misdepiction of what's going on. And most importantly, we have treatments now. We understand when a pregnancy must be terminated for medical reasons. We also understand that there are certain kinds of terminations that are not for pregnancy. They just it involves a treatment, such as for an ectopic pregnancy. And we also have medications that double as treatment for pregnancy loss, a miscarriage, and for other conditions where the same medications are used to treat other conditions. So we have a much different healthcare system and a much different social system and a much different set of social expectations that people will be able to make these very important decisions with privacy and autonomy and dignity. And now we are seeing the opposite.
Yeah, I mean, it's really, I think, important to emphasize how the medication abortions, as you mentioned, can be used both for abortions and treating of miscarriages. Are, that's changed how people receive abortion care, with now over 50% of abortions done in that manner, up to 10 weeks. So Alan, the Mississippi law that was upheld in Dobbs had no exception for rape or incest. What does Dobbs tell us about what exceptions are required, if any, in the various states that are enacting abortion bans right now? And what is the implication of what Dobbs does or doesn't say there?
The first question, of course, is what the state decides to do, but let's assume for the moment that the state is going to have no exceptions at all. If that is the case, then the opinion by Justice Alito says that the standard of review is whether the failure to have an exception has a rational basis in the law. And when you start off with the reason for upholding the abortion, which is the abortion ban, which is to assure the protection of a potential life, as Justice Alito puts it, it's pretty clear to me that the fact that the potential life arose from a rape is essentially irrelevant. And I think almost nobody thinks that there will be a constitutional exception for that. Incest is, of course, in a way, a form of rape, insofar as it produces pregnancy. So it's essentially not much of anything to worry about in context. Indeed, the Idaho statute in the case that the Justice Department filed yesterday refers to incest in terms of marriage, which of course has nothing to do with the particular problem of abortion. So what about the exception for the life of the mother? The Idaho statute is very strict on that. It has an exception for the life of the mother if it is necessary. That's the word in the statute. Very unclear as to who makes the determination as to what is or is not necessary. But it has express exclusion that a doctor may not consider necessary if the patient asserts that she will harm herself if she does not have abortion. That's not legally considered appropriate. I think there's a very serious question as to whether any exception for the life of the mother has to be included in the abortion as a matter of constitutional law. After all, if the question is in a balance and due process balance, in which all the cases that Justice Alito cited came out in favor of not protecting the due process, or in some cases equal protection rights of the claimant, the court could easily say, if Mississippi, for example, decides to have a law with no exceptions for the life of the mother, and that justifies that on the theory that the mother has lived X number of years already, and we want to assure that the next person can come into the world, and therefore, if the mother dies and the infant lives, that's a perfectly rational reason for us to do so. Indeed, the court might well look to the law of self-defense. Which is, after all, essentially, it's okay to kill somebody else as long as you're saving your own life, but this would be kind of a reverse self-defense. So I have very little expectation that any of the exceptions would be mandated as a matter of constitutional law under any of these scenarios for this court as it now stands.
And of course, by implication, there's clearly no health exception that would be required. If you think that there would be no life exception required.
Oh, yes.
Yes.
Yeah, absolutely. And it means
that isn't close.
And it means that it's basically, I mean, to put it in its bluntest form, it is not safe to be pregnant anymore. And it is not safe to go into the practice of obstetrics. You simply cannot practice obstetrics under these conditions. You probably can't practice gynecology either, because there are conditions that arise that require the kinds of treatments that might arise in a pregnancy. So the situation is really quite desperate for everybody. This is not just about the health equity side of all of this, which has gotten so much attention, but it really raises questions for all of us.
And of course,
oh, go ahead, Alan.
Yeah, I was just going to say, there's always uncertainty about whether something is medically necessary or not necessary. But doctors are used to having those determinations judged by their peers, or at worst by a jury in a civil case where there may be money damages.
Totally.
We're now such a situation where the first question is going to be whether the district attorney is going to bring an indictment because she or he does not think it was medically necessary. That immediately is an area that doctors don't want to get close to as well. And then, of course, it's up to the jury in the end, in some of these cases, to make that determination. So very scary for medical professionals of all kinds.
Yes, and I think this highlights the point that the Dobbs decision doesn't just impact people who are pregnant and want to end a pregnancy. It impacts people who want to be pregnant, who are pregnant, in part because there's going to be questions about whether doctors are able to exercise their clinical judgment because of fears of civil or criminal liability. But essentially, the decision impacts the state of reproduction from conception, even preconception, to delivery. So for example, states, as this opinion seems to allow, could grant personhood rights to embryos, which could potentially impact IVF. Which often in vitro fertilization, which often involves the creation of extra embryos, or that can involve pre-implantation genetic testing, where embryos with genetic mutations could be discarded. Would the law prevent the freezing, the destruction of these embryos, or even the freezing? Because wouldn't it be child abuse to freeze a child? Prenatal care, as Sarah's going to talk about in some more detail, could be impacted in many ways. So, for example, providers in states like Texas and Oklahoma that create civil liability for aiding and abetting abortions could be reluctant to even talk about abortion options in other states, or there might even be explicit prohibitions on such discussions, or even to recommend things like prenatal testing, knowing that many people seek prenatal testing with the possibility of wanting to terminate if there are abnormalities. Managing miscarriages, something that Sarah mentioned, raises all sorts of legal issues for providers. As she mentioned, the procedures and medications are the same for both of them. Even the term miscarriage is defined as spontaneous abortion. So it has that word abortion. It can be confused by prosecutors as being distinct from what we're calling abortion in the common use of the language. Patients with non-viable pregnancies might be denied standard of care because of fears of liability. In the period since SB 8 has been enacted in Texas, data from 2 major hospitals in Texas found that patients with non-viable pregnancies, so there wasn't going to be a child born with this, had to wait 9 days until the fetal heartbeat stopped, or until the pregnant people were so sick that the doctors could take medical action. And the result was that more than half ended up with serious infections or hemorrhaging. And if states start to enact laws where women could be prosecuted for abortions, which there's division in the pro-anti-choice movement, but we could see this happening. There are concerns about surveillance pre-pregnancy, throughout pregnancy. Will states, as Missouri did, track fertility apps to see who's pregnant and then thereby who's losing pregnancies? Would there be surveillance about behaviors during pregnancy? So not just illegal drug use, but even things like alcohol, using a hot tub early in pregnancy, eating sushi, things that could threaten the well-being of the fetus. And then we could also see growing state control over decisions throughout the pregnancy up until the point of delivery. So for example, if a doctor recommends a particular delivery procedure like C-section and the patient doesn't want that, will doctors be inclined to get courts involved more than before? Will courts intervene? What happens if a pregnant person rejects that decision? Can the state come in and restrain? We have already seen those kinds of maternal fetal conflict cases, but we will see many more of them with these laws. So that's sort of some examples of how various stages of pregnancy are affected by the decision. Sarah, can you talk a little bit more about the impact of this decision on the healthcare system as a whole, including interference with clinical decisions, as we've both been discussing?
Sure. I think there are sort of 2 bins that I've been putting my thinking into. One is as a member of a public health faculty, what will be the range of population level effects of all of this, and how quickly will we start to see it? And we know, of course, that one of the most important things in a pregnancy, in a healthy pregnancy, is a planned pregnancy, a pregnancy that happens when people are ready to have a child and want to be pregnant and are in a position to be able to support a pregnancy. And we know, of course, that contraception can fail. And so while you can take great care not to have a pregnancy that you didn't intend to, life does not always work out. And what we know about pregnancies that are not planned well, where you're healthy and in a strong position going into the pregnancy is that there are much worse results. Pregnancy is a high risk period. The risks associated with a pregnancy are exponentially greater than the almost no risk situation with abortion, particularly very early abortions. Pregnancies can trigger all kinds of health risks. The rate of prematurity goes up. The rate of low birth weight goes up. Maternal mortality rates go up. We, of course, are right now in a terrible upswing in maternal mortality rates in the United States. Infant mortality, of course, rises. Maternal morbidity rises, as Sonia was describing. The long-term consequences of a poorly managed pregnancy can be that women are unable to get pregnant again. They have permanent injuries. Child welfare of children is at much greater risk where pregnancy is unplanned and nobody is ready or able to manage birth and childhood. So what we've done with this decision is trigger a whole constellation of results. And it is a particularly difficult decision, in my view, to sort of accept from a health policy perspective, given the fact that we have no maternity care system in the United States. And in some countries, other countries may have a more regulated approach to abortion, abortions that are not a matter of medical urgency or medical necessity may not be lawful, say, after 15 weeks or 18 weeks. If you look at these countries, though, they have universal maternity care, they have universal child leave policies, they have universal family supports, they have universal benefit systems, child welfare, daycare, you name it. They have all kinds of basic services in place. Things are so shaky in this country, particularly in medically underserved communities, of which there are thousands in the United States, that if you look at the maternity care systems on which people are going to increasingly depend in these communities, you see that the entire healthcare system just is not in a position to respond. And this is before obstetrics became the high-risk profession it now is turning out to be. We looked recently at the nation's community health centers, which are a huge source of healthcare, including maternity care across the country, particularly in underserved rural communities. And there are states where, among all the health centers in the states, there are no obstetricians. They are literally having to make do with family practice doctors who are very capable of doing deliveries, but they also have to do everything else at the health center because health centers take care of people from birth to death. They lack the money to build out their systems. They're understaffed on physicians, on nurse practitioners, on midwives, and even the health centers in non-banned states, the states that have not reacted the way they have, are oftentimes bracing themselves for huge spillover effects from the states with bans because people can't get what they need from clinics in those states. So we just don't have the capacity to have the kind of surge in childbearing and pregnancy needs that this decision likely is going to trigger in a lot of parts of the country. And I don't really see any major response either from Congress or state legislatures. I mean, so far, the deluge of bills that everybody was promised that would immediately rush resources and services to families who need them in the wake of Dobbs has not materialized. There's just nothing. And so here we sit with safe pregnancies now thrown into disarray and with no maternity and infant care system to fall back on.
Sarah,
Yeah, and
can I ask, Sarah,
go ahead. Yes.
what is there a correlation between the states that have bans and the states that have very little medical assistance for pregnant women?
That's a great question, Alan. We submitted a public health brief on behalf of the American Public Health Association and almost 600 deans, chairs, scholars from across the country. Dean Goldman was one of the leading deans to sign on behalf of schools of public health. We presented the court with extensive data on the absence of all of these very, very basic services: Medicaid coverage, WIC benefits, the food benefits for low-income pregnant people and their children, basic income assistance, housing assistance, child care services. A lot of data was presented to the court. And I think that we were about the most extensively cited brief. Unfortunately, it was in the dissent. We were heavily cited in the dissent as the basis of evidence for the consequences that the majority simply did not consider. The majority's response was to say that women don't need any of these services anymore. They're very successful.
And leave it to the legislature.
Yep.
And of course, and you sort of alluded to this, I mean, you're not going to have the obstetricians and gynecologists, and you're not going to have the training in how to perform abortion. So even in states that allow exceptions for to protect the life of the mother, will there be anybody there who can actually do that?
Well, and things are so terrible, actually, that in at least one case, a request has been made to move the specialty certification exam out of a banned state because it is not possible to train people to meet the minimum requirements of the specialty.
Yeah. Well, so with that background, now there's some sort of specific legal questions that, I mean, there are many, we won't get to all of them today. Lawyers are going to be very, very busy in the coming years dealing with so many questions. The idea that this decision was going to sort of end litigation and debate is just wrong because there's so many questions left. So Ellen, let's think a little bit about travel. So Kavanaugh is very optimistic that there's a clear constitutional right to travel, and that might be the only way that people in some of the abortion restrictive states can access abortions. Is Kavanaugh right? Is there a clear constitutional right here?
Well, I think he is correct. Of course, it doesn't solve the problem of money and how people are going to be able to financially travel, and they're going to find places, someone to take care of their kids, or how they're going to walk away from their job for whatever time it takes. And of course, the travel costs are very high these days. Airfares are going through the roof again, and many people have to drive 500, 600, 1,000 miles to get an abortion. There's a case back in the 1970s called Bigelow against Virginia. Mr. Bigelow ran an alternative newspaper in Charlottesville, Virginia, in which he placed an ad was placed for an abortion clinic in New York when abortions were legal in New York and banned in Virginia. And the state of Virginia charged Mr. Bigelow with a crime for aiding and abetting obtaining an illegal abortion. And in the course of the opinion, which ultimately was decided on First Amendment grounds, the Supreme Court said expressly that the state of Virginia has no business in trying to regulate what happens in another state. And that it has no power to do so. It can regulate what happens in Virginia, but not in another state. Since that time, the court has also decided several right to travel cases, all of which, some of them coming in the opposite direction, in the sense of the incoming state trying to put restrictions on people who get food stamps or welfare benefits. But the court made it pretty clear that that's not the business of the states to fence people out or try to reach extraterritorially. And so I think that Justice Kavanaugh is correct. Now, he didn't even bother to cite any cases. He thought it was so easy. And the Justice Department has previously said, and the president has previously said, and I understand that today he's going to issue another executive order implementing the role of the federal government in assuring that there is a right to travel. Whether he'll be able to provide any funds for people who need to travel, that remains to be seen. But as a constitutional matter, I feel quite clear, as I felt quite clearly the opposite way on the exceptions, that the right to travel would be upheld, and that the Supreme Court would not allow Texas, for example, to try to penalize somebody who criminalize somebody who went to another state, or a doctor who advised somebody to go to another state to have an abortion.
Yeah, and I would assume, if I can just note on the right to travel, Medicaid law, federal Medicaid law allows states, actually requires states to pay for medically necessary transportation. Now, in the case of an abortion that's indicated for health reasons, in theory, that would be transportation for a medically necessary service, as opposed to an abortion potentially. In Medicaid, many things can be many things at the same time. And so that may be what the administration is preparing to argue. The interesting question is the use of powers, and it would be an innovation to step in when a state will not pay for the transportation itself. Normally, you know, the federal government would say to states, you must pay for this, and if you don't pay for it, we're going to keep sending you letters that you have to pay for it. But here, the interesting question is whether they have figured out an approach that will let them literally default to a federal payment when the state refuses to make a payment.
Could the federal government advance payments? You think advance the money and take it out of the state share of their Medicaid?
Well, they may
be
be thinking that what they're going to do, although really it's a form of equitable relief almost, that the federal government has never ever done when the state refuses to pay for medically necessary required services service under law. So I think those of us whose lives revolve around the 4 billion page Medicaid statute and the 12 billion pages of rules are eagerly waiting to see how they develop an approach to this kind of structural challenge in Medicaid.
And then, of course, you know, there are going to be attempts to say that Hyde Amendment prohibits this and sort of
that's an abortion service. So
exactly right. So there's going to be a lot of litigation over that.
Yes.
Another big area, and this covers lots of different areas, is preemption. So whether existing federal laws preempt under the supremacy clause any state laws that are in conflict, and there are a few areas. So one, you talked a little bit about Emtala. Maybe you could say some more about that. There's a lawsuit that Alan referenced in Idaho going on, and also Title 10 regulations. And I'll talk a little bit about medication abortions. But Sarah, do you want to start us off with the Emtala discussion?
Sure. So Emtala is is an example of a law that didn't exist in 1973. It had no place in the pantheon of American health law. There were some state law precursors to Emtala, but not much. And Congress, states in the early 80s, and then of course Congress in 1986, very celebrated move, established a new federal requirement for all hospitals that participate in the Medicare program and that have an emergency department. So that's virtually every American hospital participates in Medicare, and most hospitals, there are some exceptions, like the rehabilitation hospital here in Washington does not have an emergency department, but generally speaking, hospitals have emergency departments as a condition of licensure. And if you have an emergency department and you want to get paid under Medicare, which is the biggest public payer of hospital care, you have to screen people who come because they think they have an emergency medical condition, and you have to stabilize the condition until the person's either transferred to another facility or discharged, sent home. And an emergency is defined in the law as a health threat. It's not a life threat. It's a health endangering situation. And Congress very deliberately in 1986 rejected a life endangerment standard, which was a common law at that point, in favor of a health endangerment standard. And stabilization is a no material deterioration standard according to medical judgment. And so you now begin to see this headlong clash between what Emtala requires in the way of hospitals, and it makes very clear that this is a national federal standard. What Emtala requires and what state abortion bans are going to prohibit. Texas, about a minute after the federal government issued clarifying guidance on Emtala, Texas sued to stop the guidance from taking force in Texas. And no state joined Texas, interestingly. The department hasn't answered yet, but now the Department of Justice has stepped in to sue the state of Iowa.
Idaho.
Idaho, which has arguably the most restrictive ban there is, in which literally it's essentially a homicide statute, and you can defend yourself in court by arguing that it was justifiable and presenting evidence that you can prove a life endangerment situation. As Alan pointed out, good luck with that in terms of how that evidence gets weighed. And the effect, of course, has been to shut down emergency care. And so justice has sued to bar the state of Idaho from implementing this law, which is set to take effect in a couple of weeks. And I suspect that before all is said and done, we're going to have a dozen of these cases. Any state that has anything but a health endangerment standard that reflects Emtala and defers to medical judgment, does not pursue any case in which the providers after the fact provide the kind of evidence that you would always have to provide anyway of medical judgment if need. So that's where matters stand on Emtala.
Can I say a couple of things? In the complaint, the federal complaint in the Idaho case, the federal government pointed out that 43 of the hospitals in Idaho take Medicare, but only 39 have emergency departments. Right. And of course, that doesn't deal with any of the abortion services or other pregnancy services that are handled outside of a hospital. Second,
right, it's just hospital emergency.
Just hospitals. So, and the second is the Idaho law, of course, makes it a crime for the physician to perform the abortion. But if you work at a hospital, or you're an anesthesiologist, or in the nursing department, or if you're the chairman of the department, you could easily be sued for and criminally charged with aiding and abetting an abortion if you don't do what the state of Idaho says you have to do, right, to protect this on the Emtala. And finally, and I don't know how this term will be interpreted, but the statute provides that the requirement is that the person be stabilized, and that may not be enough. That is to say, stabilization, and then they could send them to someplace else or discharge them, and that may not be enough to protect the life of the
right.
mother.
What you're pointing at is that Emtala is hardly the be all and end all.
Yes,
but Emtala is the sine qua non at this point of the right, if you are near a hospital with an emergency department, the right to go there if your health is in danger and be stabilized. And that is what's at stake here. And I think that despite Emtala's limitations, its importance in all of this should not be underestimated.
Right. It was originally passed because hospitals were turning down patients who they knew couldn't afford to pay for the coverage on an emergency basis. And the courts and Congress said, no, you can't do that.
Right.
So in the interest of time, I think we're going to skip over the Title 10 preemption, because I think it's worth discussing the preemption about medication abortions. Where there's already some litigation involving that. So medication abortions are allowed, FDA allows them up to 10 weeks. They involve 2 drugs. Mifepristone is the first one, and then misoprostol. Mifepristone is regulated pretty stringently by the FDA under what's called the Risk Evaluation and Mitigation Systems, the REMS. And recently, I think it was late December, it allowed the use of telehealth to prescribe the drug. So before you had to prescribe it in person, but there are still other restrictions that remain. Certified providers are required to prescribe, certified providers or pharmacists to dispense. So it's still pretty strongly regulated by the FDA. And so then that raises questions about whether state laws that conflict, that are more stringent or that ban the medication abortions, whether they're preempted by the FDA. Right after Dobbs was decided, the AG, Merrick Garland, issued a statement declaring that the states can't ban mifepristone, quote, based on disagreement with the FDA's expert judgment about safety and efficacy. course, the question is, are courts going to agree on this? So there is a pending case that actually began before Dobbs was decided. Mississippi prohibits the use of telemedicine to prescribe mifepristone, and of course now it has a trigger ban in effect. But GenBioPro, which is the only generic manufacturer of mifepristone, went to court arguing that the FDA's dispensing and prescribing regulations preempted that law, and then recently sought to amend their complaint to include Mississippi's trigger law. And essentially that these laws cannot be in effect because of preemption. So that turns then on what Congress's purpose was in regulating pharmaceuticals. Is there explicit or implicit preemption? The Supreme Court has said that Congress didn't expressly preempt state laws when it created legislation governing pharmaceuticals. So then that means that states have to look to the implied purposes. And scholars have suggested that there's maybe three ways to find implied preemption here. One is that Congress's purpose was to ensure patients' access to safe and effective drugs, and anything that restricts that is in conflict, that its purpose is to establish uniformity in drug regulation, or that its purpose is to achieve a particular balance of risks and benefits and efficacy, which, for example, was done with the REMS for mifepristone. There is a case from the District of Massachusetts suggesting that states can't regulate FDA-approved drugs to make them less accessible. So that dealt with a newly approved opioid. And in that case, Massachusetts had initially banned the drug. And then when that was considered to be preempted, it more stringently regulated the drug than the FDA. And the court again said that that was preempted. And finally, when the regulation essentially mimicked that of the FDA, did the court allow the law to stand? States might come back and respond and say, well, we have the authority to regulate medicine, and that includes prescribing drugs. That argument didn't fly with the opioid litigation, but we'll see if other courts would accept it. Things get a little bit more complicated if the state isn't expressly banning the use of mifepristone, but instead banning, say, all abortions, including medication abortions. So would a general abortion ban be preempted? Now, if you view it as a ban of the drug, the opioid case would suggest that that's problematic. But the state might come back and say, well, we're not banning the drug. We're just banning medication abortions. And so that's different. Now, the counter to that would be, well, mifepristone was approved just for abortions, and the REMS make it really hard to do any other off-label use, so that in effect, it is a ban. And then finally, states might say, when you're dealing with something as sort of political and important as whether states can ban medication abortions, Congress has to be express in its desire to preempt state law, and Congress hasn't said that that's what it's doing. So many, many legal questions that remain there. So I think we're at 1:42. So we'll open up for questions. Zoe, looks like we have a few questions here.
A ton have come in already. And some you've already answered, I think. But there's a question from a reporter who says, there are now worries about a prosecutor's access to data and medical information. Is it fair to say that an abortion provider could risk not only violating a state law for performing an abortion, but also potentially violating federal law like HIPAA for disclosing patients' health information on abortion?
Yeah, that was actually something that, had I had time, I would have gotten into a little bit. So I think the question about whether the information can be shared about patients' abortions, HIPAA allows for some disclosure of information in certain cases, including for law enforcement purposes. Now, there's the limit. It can't just be sort of anything. But if the state were to require reporting of abortions, that's another exception under HIPAA. And so state law could, because the states allowed this, HIPAA gives that sort of exemption right there. So I think that the physician may be permitted under HIPAA to disclose that information, and in some cases may even be required. Now, I think that there are questions about, how narrowly, what kind of information. They can't just sort of go to the hospital and say, tell us about everybody who's had an abortion. I think HIPAA wouldn't allow that, but there is that sort of concern. One related sort of question is, a lot of states now, the sort of safe haven states, are trying to protect red states that are seeking to sort of extend their laws into blue states. So say Missouri had a law where they haven't implemented this law, but they considered a law that would allow for civil liability against people who aided and abetted people from Missouri going to other states to seek abortions. So let's say Missouri was trying to go to healthcare providers in Connecticut to access information about patients' abortions. Well, Connecticut has a law that says that providers cannot share information about abortions with states seeking information through subpoenas for litigation. The problem is that information might still be able to get to the prosecutors, the law enforcement in Missouri, if the information reaches other healthcare providers, because HIPAA does allow for the sharing of information among providers for purposes of patient care. And there are now efforts to expand the sharing of information, again, for purposes of patient care. And there's an information blocking rule that's trying to discourage things that stop information from going across state lines to get from one provider to another. So if those records were shared with another provider for purposes of patient care in Missouri, then law enforcement could access that information. So I think there are lots of really big privacy questions here about how much protection there actually is, which is a slightly different question than what the reporter asked.
Yeah, I wonder if I could just jump in with one other thing, which is I know that the administration is thinking about limiting the HIPAA deference to state legal requirements for information, and one possibility is they could say, look, where the prosecution is asking for information to prosecute physicians for complying with federal law, then HIPAA would bar that kind of request. It is an unlawful request. So whether they're going to carve out, they're going to assert their authority to carve out what they continue to be unlawful requests for information, because it's to aid a prosecution, civil or criminal, that's blocked by federal law. I don't know.
Yeah, and of course, if the administration changes, then
that too.
There's a follow-on question that sort of came from that when we were talking about prosecution. Someone's asked, can prosecution be retroactive? Can someone who had an abortion years ago in one of these states with bans be at legal risk now? And I'm guessing that person isn't a lawyer, but I'm hoping that you guys can clear that up quickly.
I think the answer is no. I don't think that necessarily would stop any district attorney from wanting to do it. However, if the law was on the books and they said they violated, and the only reason we couldn't enforce it was because the Supreme Court said it was unconstitutional, I can imagine some quite vindictive prosecutors coming after them. I'd be glad to help the defense in that case.
So then going back to the privacy kinds of questions, to what extent can law enforcement access data like apps that track menstrual cycles and the information in them and things like that?
Yeah, I think this is another thing that the Biden administration is going to really need to look at. In the July 8th executive order, it did say it was going to explore more stringent privacy protections. And this is another area where we need much better protection. So the privacy apps are not protected by HIPAA, so that doesn't offer any protection. There's questions about whether FTC should get involved in regulating in this area. But as I understand it, Missouri was using some of the fertility apps with patients who went to Planned Parenthood. So I think that is a very risky area right now for people aiding and abetting abortions because of the possibility of getting information through those apps. And so we need better protections there.
So you just mentioned what we're starting to see from the Biden administration in terms of executive orders and his task force, right? And we have some additional language from him on Emtala. You talked about what we're expecting to see today. What else are you expecting to see from the Biden administration through executive orders? And how likely do you think any of that will be to end up in the courts?
Well, we didn't have a chance to get to it, so maybe this is a good time to flag it. So the Title 10 family planning program is the nation's largest single program that's dedicated solely to funding and supporting family planning clinics. And after a long fought battle, the Biden administration restored what is called non-directive counseling under Title X, meaning if you're pregnant, if you go to a Title X clinic and you get a confirmed pregnancy test, you have the right to have impartial counseling about your pregnancy options at that point. So now the question is, what happens if you're in a state that has an abortion ban of some kind or another? And one question is whether there's going to be a directive to ensure that people who are served by family planning clinics, and I should note by community health centers as well, they are not explicitly obligated to do non-directive counseling as a condition of their federal grants, but they are expected to follow medically appropriate, clinically appropriate practice standards, and you don't withhold information from patients. And so whether because you're directed by a third party, meaning your grantor, to do so. There's actually a classic health law case that says it's no excuse. You can't withhold information. And so the question is, will these clinics be directed to continue to provide impartial information, including the Justice Kavanaugh Memorial right to travel to another state, and where and how to secure travel funds to get to another state, and how you can get help? Or will they be told that they have to follow the requirements of the state in which they're licensed? Because of course, all of these clinics have to have state licensure status in order to get Title X or 330 or any other federal grant funding. So, I mean, we have thousands. Ryan White Care Act clinics are in the same predicament. Community mental health centers are in the same predicament. All of these clinics that we give funding to help them reach underserved populations are licensed health clinics that get federal funding, and the federal government expects them to practice good health care. And so, you know, what is the government going to do with these programs?
You know, I was thinking that we used to say that when a doctor graduated from medical school, to get a stethoscope. Now I think we ought to give them a right to counsel to be able to work through all of these problems, especially if they get an obstetrics degree.
Right.
Specialty.
There's a question that came in. Do you think that litigation using religious arguments, that bans are contrary to some religions? For example, I'm Jewish, and it's in my religion.
Sincerely held religious belief.
Exactly. So do you think those religious arguments to counter some of this will have any chance of success?
I asked my religious experts, Chip and Bob, and they almost laughed me out of.
I mean, RFRA is a federal law. These are state laws.
Well, but there's a state. Anyway, the answer is not this court.
Yeah.
But I don't even understand how the RFRA, with Religious Freedom Restoration Act notion that you can have a sincerely held religious belief that would exempt you from a state medical practice law. I mean, if a state outlaws a medical practice and says the only exception is life endangerment, it falls under, I would think, under the category of state public health laws for purposes of this court. That are across the board restrictions, and you can't claim a religious exemption.
Yeah.
Yeah. I mean,
Neither the doctor or the patient.
No, nobody.
I think you could take the reasoning that this court has used in other cases about the exercise clause and argue that there should be such an exemption.
Yeah.
Want to be consistent. That is a different point than saying whether this court would in fact argue for such consistency.
Quite
and
so.
I agree with you, Alan. I do not think they would. Although I think you could clearly make that argument from other cases, even outside of abortion, that would support this. But I don't think they would.
Do you think that there are successful arguments around state interference with medical decision-making, or do you think that that will also fall on deaf ears?
I think that will as well. Look at Gonzalez. We can go even to a more liberal court in 2008 and see where they said that essentially, if there's any question, if there's any division of opinion, then the legislature decides. The idea of deference to healthcare providers in medicine generally, but particularly in the abortion context, just over now.
Yeah, and Rust v. Sullivan as well, the family planning case, you know, that it's perfectly fine to enact laws that pick and choose what the right medical care is. I mean, that's sort of the court has been there for in different contexts at different times. I do think at the point at which the laws are so unreasonable that they put people's lives in danger. I mean, I think Gonzalez in that sense outlawed a particular procedure. There were other procedures that could be used at those stages. Where we have a state law that is now threatening the life and health of people because it is compelling substandard care, whether you now lose even a minimum rationality justification for that kind of a law. We don't know. There's so many things we don't know.
Yeah.
So there is one area where I've been exploring, which is that because of the very uncertainty that Sarah just mentioned, doctors don't know what to do.
Right.
And the Supreme Court has been quite good in an area called void for vagueness, a case called Johnson against the United States on criminal law, and in that case sentencing. But it's been very clear it applies to the merits of criminal prosecutions as well. And the court has said, no, you have to be clear. You can't put people at risk of not knowing what's at issue. And, you know, I took a look at the Idaho statute today, and it's really very unclear what the word necessary means. In addition, there is an exception for rape. I point out that they require that the victim have reported in writing, mind you, and they have to bring a copy of what they provided in writing. Oral protests of rape are not good enough to the doctor before they can get. The Idaho statute has 10 different grounds on which rape could be charged, and it's unclear whether you'll have to specify which of the various grounds were for rape, whether it's statutory rape because of age differential, or the person was inebriated or asleep, or one of the various other exceptions to them. And then the real question is under this statute or other statutes as to whether, and this is an affirmative defense that the doctor must prove by preponderance of the evidence that it can't get dismissed without that, is could the prosecutor say, well, actually, the person wasn't raped, they made it up. And are we going to have rape trials in the middle of abortion proceedings? And more significantly, is the doctor going to be so worried about having to even think about that she or he is just simply going to say no? And all the rest of the people at the hospital are going to say no because they don't want to be involved. It's just the path of least resistance. And that's the area where void for vagueness is really worth pursuing by doctors who have to make these terrible, terrible choices.
Yeah, they are terrible choices, and quite apart from the being challenged to not be able to exercise their clinical judgment, they also are at risk of other liability. So either way they go, there's sort of threats of liability, which is it's a terrible place to put them in.
Which is why we won't have any anymore.
So it looks like we have a ton of additional questions that have come in, but given that we have a couple of minutes left, I guess what I would like to know from all three of you is, given the division across the states, the very dire consequences for people who may find themselves pregnant and have complications or not want to carry to term, what's your best advice for people on a day-to-day, on a really practical level about this? Because someone asked a question specifically about, should we be stockpiling medications to assist other people? Should we be working for companies that have travel assistance, things like that? And I guess I'd like to take it down a bit from the legal issues to what's the day-to-day? How are we all supposed to handle this stuff? Because it's huge.
Well, I mean, I can tell you as a practical matter, if I were living in one of the states that Sonia has pointed to, I would say it's not safe to become pregnant. And you should probably be on the most effective contraception you can find and avoid pregnancy risks, because as at least a couple of us on this Zoom call have had pregnancies. I've had pregnancy with complications. And I would say that this is a truly unnerving state of affairs for people. So that is not my answer as a lawyer. That is my answer as a human.
Yeah, and I think the stockpiling, my daughter is taking a gap year, but maybe going to college in Indiana after that. I would recommend stockpiling for her and any of her friends. I think, and part of the other discussions, if you have any complications, go straight to the ER, right? So that depending on how the Emtala litigation goes, so that you hope that you can at least, fulfill some of the requirements of that. I didn't know if your question was more sort of as individuals or as people who are trying to ensure and help other people achieve access, because it sounded like it
I
might
think
be
it's both. I think it's both.
So I have one word, and the answer is Kansas. Meaning
Yeah.
people have got to get politically active
Mhm.
and
Gotta vote.
make it clear that this state is the state of uncertainty and excessive banning is unconstitutional. It's not. It's going to be politically.
It's not going to
death.
happen here.
It's going to be politically death for the people who support it, and it's up to all of us
Right.
to take that position.
And the decision does not reflect the views of America.
Yes.
Nope.
It doesn't. And so you're right. Voting is the single most important thing. So I think we are right at 2:00, and I'm sorry that we couldn't get to everybody's questions, although somebody asked if it will be made available. It will be posted on the law school website, certainly on the health law portion of it, but perhaps on the main website as well. So thank you to my colleagues and
you.
Zoe.
Thank you.
Everybody for attending.
Thanks for doing this. Bye.